The attempt by the House of Representatives to reform Nigeria's criminal justice administration is our focus on today's edition of Law Weekly. The chairman of the House of Representatives Committee on Justice, Honorable Ali Ahmad, will share with us the major innovations in the administration of criminal justice bill. But before we get to that interview, let's take a quick look first at some of the top stories from the court. I am Shola Sheele, and this is Law Weekly on Channels Television. Last week, Tuesday, the federal government arraigned two journalists with the leadership newspapers on charges of felony and conspiracy against the Federal Republic of Nigeria. Mr. Tony Amokeldo and Chibuzo Kaibe were arraigned at the Federal High Court in Abuja for fraudulently altering and publishing a false document with the seal of the president. They pleaded not guilty and were granted bail. 2 days after that arraignment, the federal government, through the Office of the Attorney General, withdrew and discontinued the suit against the two journalists. It still remains unclear why the suit was withdrawn, but Section 211, subsection 1C of the 1999 Constitution, as amended, gives the Attorney General of the Federation powers to discontinue proceedings. In exercising the powers, the section says, the AGF shall have regard to the public interest, the interest of justice, and the need to prevent abuse of the legal process. Staying in Abuja, the High Court has fixed the 10th of May to rule on an application by the former chairman of the House of Representatives Ad hoc Committee on Fuel Subsidy Regime, Honorable Farouk Lawan, and the Secretary, Mr. Boniface Emenalo. The application seeks to have the court quash the 7-count charge preferred against them by the Independent Corrupt Practices and Other Related Offences Commission, ICPC. The Anti-Corruption Agency had put Honorable Lawan and Mr. Emenalo on trial for allegedly collecting the sum of $620,000 as bribe from Chairman of Zenon Oil and Gas, Mr. Femi Otedola, ostensibly to delete the names of the latter's companies, Zenon Petroleum and Gas as well as Synopsys Enterprises Limited, from the list of companies allegedly found to have defrauded the federal government of billions of naira. However, the accused persons have argued that the Commission has not established any prima facie case against them to necessitate or warrant their being put on trial. From Abuja, we move to Ondo State, where the Governorship Election Petitions Tribunal sitting in Akure, the state capital, last week Friday affirmed the victory of Governor Olusegun Mimiko at the October 20, 2012 elections in the state. The three-man tribunal, in a judgment delivered to a full courtroom, dismissed the petitions of both the candidates of the Action Congress of Nigeria, ACN, and the People's Democratic Party, PDP. The tribunal held that Mr. Oluwarotimi Akeredolu, SAN, the candidate of the ACN, failed to prove beyond reasonable doubt all the allegations of corrupt practices and non-compliance with the Electoral Act, which he alleged. The court also held that the PDP and its candidate, Chief Olushola Oke, also failed to substantiate with credible evidence the allegations of voting without accreditation, thumb printing, ballot snatching and stuffing, and multiple voting. There are already indications, though, that the petitioners are considering an appeal of the judgment. In Lagos, a federal high court last week Thursday upheld the powers of the National Assembly to legislate on how political parties should nominate candidates for elections. The court was delivering judgment in a suit filed by the Action Congress of Nigeria, ACN, which sought a declaration that the procedure adopted by a political party for the conduct of primaries for nomination of its candidates in an election is outside the legislative domain of the National Assembly. The ACN specifically attacked the provisions of Section 87 of the Electoral Act 2010 as amended and sought a declaration that it was inconsistent with the provisions of Section 4 and Section 228 of the 1999 Constitution as amended. Section 87 of the Electoral Act 2010 as amended lays down the procedure for the conduct of primaries by political parties seeking to nominate candidates. The court held that the exercise of the National Assembly's regulatory powers, as contained in Section 228 of the 1999 Constitution, gave rise to the enactment of the Electoral Act, and it therefore refused to invalidate Section 87 of the Electoral Act 2010 as amended. And we round off in the UK, where the Royal Court of Justice on the Strand in London last week Thursday threw out an appeal by former Governor of Delta State, James Ibori, to have his 13-year jail term reduced. Two justices of the court dismissed the appeal, thereby affirming the prison term handed to the former governor for money laundering, stealing and embezzling of over $250 million belonging to Delta State, Nigeria between 1999 and 2007. The former governor, who was not present at the court, was last year April sentenced by the Pseudo Crown Court in London. His supporters, however, thronged the court premises, calling for his freedom.
You see, life has just got easier. You stay connected to Channels TV, where news and innovations are shaping our world. Simply log on to channelstv.com to get the breaking news. Browse the homepage according to what matters to you. Tap on the extended coverage of business, sports, politics, lifestyle, infotech, entertainment, health, world news, and lots more. Click on the live link and see the news in real time. Do you want to watch the latest video of the day? It's just a click away. Friend us on Facebook, YouTube, follow us on Twitter, Google+, participate in Channels TV poll and share your comments. It's a website you can talk to. Your voice will be heard.
channelstv.com. The news at your fingertips.
Welcome back. Nigeria's criminal justice system comprises of a network of laws and institutions that works in a process that is supposed to be coordinated to ensure quick dispensation of justice. Over the years, however, the criminal justice system has frequently been viewed by Nigerians as ineffective, unjust, repressive, and in need of urgent reform. The process commences when the police has a reasonable suspicion that a person has either committed a crime or is committing a crime. It continues through the courts to the end of trial, through sentencing, imprisonment, and release upon the completion of a sentence. Other institutions involved in the process, apart from the police, are the Ministry of Justice, the courts, and the prisons. And these are where some of the problems plaguing the system lie. They include the perceived corruption in the police force, as the men of the force are largely seen as repressive and ineffective at maintaining law and order in the society. The prisons are largely staffed by poorly paid, inadequately motivated, and insufficiently trained officials. The judicial workers, on the other hand, particularly the magistrates, are generally overworked, underpaid, and lack the court infrastructure and equipment to enable them work efficiently. The ministries of justice, both at the federal and state level, suffer from the ills of the lower courts, heavy workloads, poor infrastructure, and an uneasy relationship with the public. Section 36(4) of the 1999 Constitution envisages a quick dispensation of justice when it provides that whenever any person is charged with a criminal offense, he or she, unless the charge is withdrawn, is entitled to a fair hearing in public within a reasonable time by a court or tribunal. It is, however, common knowledge that criminal cases take unduly long periods of time to decide in court because of these stated problems. It is for these reasons and more that the current bill deserves commendation.
Honorable colleagues,
last week, the House of Reps held a public hearing on the Administration of Criminal Justice Bill. It was organized by the chairman of the House Committee on Justice, Honorable Ali Ahmad. Honorable Ali Ahmad represents the Ilorin East, Ilorin South Federal Constituency in the House of Representatives. He holds a bachelor degree in law from Bayero University, Kano. He obtained his master's in law, LLM, from Harvard Law School in the USA in 1997, and in 2000, a doctor of juridical sciences from George Washington University Law School, also in the USA. He taught law and later rose to become an acting professor of law and the acting dean in both Bayero University, Kano, and the University of Ilorin, before joining active politics in 2005. He was personal assistant to former Governor Bukola Saraki of Kwara State and later served as the Chief of Staff and Attorney General of the state before becoming a member of the House of Representatives. He joins me on the program now to give more perspective on the administration of Criminal Justice Bill. The House of Reps just had its public hearing on this bill to enact the Administration of Criminal Justice Bill, and you've been quoted as saying that there are a lot of innovative ideas, a lot of innovative reforms in this bill. Can you let us into what this bill essentially is about?
Bill, Administration of Criminal Justice Bill 2013, is an amalgamation of the criminal procedure codes of both North and South. You know that the operating codes we have now are two. One operates in the North, the other operates in the South. So this bill seeks to unify them. That is one thing. It repeals the existing one and then enacts one single criminal procedure code for the whole country. That is good for lawyers, but for ordinary citizens who come into contact with laws, especially criminal law, the bill goes further than that. It provides a lot of ideas and issues that seeks to advance and achieve those laudable provisions of the Constitution. We have those solid constitutional provisions. This bill is a step towards achieving those. For example, the bill has about over 200 sections, so it's not possible to mention all of them. It has about 400 pages, but very briefly, the salient ones. Let me first deal with those that affect human dignity, as the Constitution provides. Now, what happens now is that if the crime is committed and the police cannot find a husband or a wife or a father, they arrest the wife, holding her, hoping that the husband will come. This bill prohibits that. You cannot arrest in lieu. If somebody commits an offense, crime is personal offense. So you cannot arrest the wife or the son. So this protects the human dignity, and that it's only the criminal that should be arrested. And it places a lot of duties on arresting officers and authorities. Now, arresting officers and authorities and institutions arrest without giving a damn to the dignity of the human person as contained in the Constitution. Now, this bill imposes a duty. If you are arresting, fine. I mean, you are protecting the society, but you have a protocol. This is what you do, this is what you do.
So it spells out
what you must do. First, when you arrest, you have to document the arrest. You take his name, his picture, the crime he has committed, and then you submit that quarterly to the Office of the Attorney General. So all these arresting authority, EFCC, NAPTIV, everybody that has arresting power must quarterly submit a report to. So we don't have to rely on Human Rights Watch or Amnesty International to tell us that this is the statistic of criminals, these are the prevalent offenses. So in every 3 months, just go to the Office of the Attorney General or come to the National Assembly. Will give you the statistics of crimes that are being committed. And then one of the important, this has to do with crime records. Every criminal conviction in this country, the bill imposes a duty on the Chief Registrar of the courts to generate information and send it to the State Commissioner of Police, and then the State Commissioner of Police sends it to this, what we call Central Criminal Registry, which will be resident at the police headquarters. So at every point in time, we know who has been convicted of what offense. Now we don't have that.
So we're building a database.
Okay. Which and it imposes a sanction on the court registrar that if you don't do it within 30 days after conviction, that officer should be reported to the NJC for disciplinary actions.
From what you just said, one of the important mischief that this bill seeks to address is to cure the delay in the criminal justice system. But some people have said, what about the support system? That's talking about the police, the prison, the courts, the Ministry of Justice, because they all work hand in hand. And how is that going to, have an effect on this bill?
Fundamentally, if there is one objective that this bill seeks to achieve, that is it. To address the issue of delay of justice. We know there is delay in access and attainment of justice in Nigeria, both civil and criminal. When there are so many, these biennial reports of the World Bank, they call it doing business in Nigeria, where they compare the time lag within which it takes you to commence business transaction in the whole country, and they compare Nigeria with others, I mean, expectedly we perform very well. We can afford to do that in civil cases, but in criminal we can no longer do that because this affects life and limb of citizens. This bill has been going on since 2005, since Chief Akinolujimi's era as the Federal Attorney General of this federal. It was that kick-started, in fact, this particular idea that, look, let's do something about delay. I mean, you hear this every day.
Yeah.
So on this assembly, 7th assembly, we have an agenda. The Mr. Speaker said, look, we have to do something about delay of justice. So we started it, and you can see the bill is a classical case of to showcase the working together of executive and legislature. We work assiduously for the past 1 year with the Office of the Honorable Attorney General, who had experts and law professors, senior advocates, judges, and they worked on this bill.
So a lot of work has gone on.
A lot of work has gone on, and it's still going on, even after this hearing. Next week, I think on the 7th, the Law Review Commission is holding a symposium on plea bargaining, which is one of the aspects of the bill. So the main purpose of the bill, all the sections, all the 400 sections of the bill are geared towards addressing delayed justice. If the bill passes, then I think delayed justice, and it seeks to do that by providing for plea bargaining, by restricting the amount and interval of adjournment. Lawyers can come and, they will adjourn on flimsy excuses. Now the bill says, look, you can only adjourn criminal cases for five times. And the interval should not be more. There is time limit. There is limit, and it can't even be more than 5 times, and more than between one adjournment and the other shouldn't be more than 30 days. So you can be sure that once a criminal trial begins, it should finish within 6 months or 1 year maximum.
What about the case of appeal pending trial?
Very good. The bill says, look, you can appeal all you want. Once a criminal case starts, I'm a lawyer, and you know that the lazy lawyers, I can say, believe that the longer the case, the more profitable, the more it will. It shouldn't be.
Yeah.
I mean, you should bill your client on the basis of the outcome. Look, I'm doing this job, whether it is 1 month, whether it is 3 years, this is my bill. Give it to me and I'm going. So we say that, look, you can appeal all you want, but once a criminal case begins, your appeal will not have an effect to stay the trial. So you can
trial
go,
continues,
it continues while the appeal,
all the way to
Supreme Court.
Okay.
So now what happens? And the smart lawyer will now say, okay, the court has convicted my client within 6 months. My appeal is still going there. The court might not impose the sentence. Perhaps the sentence is 7 years, 5 years, or conviction, which is a bad record on anybody. So the client will be forced to tell his lawyers, look, drop this appeal. I don't want my name to be spoiled. I have conviction. Let's do this and let me do the proper appeal on the substance. On the substantive matter. Instead of fighting regularly. So you can see that these are things that so and you see the objection of our people and lawyers, this constitution has to be amended. We say, look, this time we're serious. We want to address delayed justice in criminal matters.
And those are the real issues.
Yes, and we've tried to find those sections and amend the relevant sections of the Constitution. So we're serious about this.
Maybe you can share some of the feedback from this public hearing that you've had with us. We've heard there were a lot of talk about plea bargaining, corruption, and all of that. What are the interesting feedbacks that you got from this public hearing?
You see, plea bargaining has drawn a lot of attention given the experience of Nigerians with the working of plea bargaining. What the bill is saying in section 270 to about 285 is that, look, what we have been doing is ad hoc plea bargaining. In fact, that's the title of a journal in the US, I think, one university journal. ad hoc plea bargaining. There's a problem when you do ad hoc plea bargaining. There's no way you won't.
What's ad hoc plea
That's what
bargaining?
we've been doing in Nigeria. Now what this bill is doing is now to regulate it. It's no longer ad hoc. There's no way you will operate ad hoc plea bargaining as we have done up till now. And I remember as in 2011 when the Halliburton case came up and the Honorable Attorney General did the plea bargaining. At the National Assembly, as the chairman of this, we sat down with the Honorable Attorney General and we said, please, let Halliburton case be the last plea bargain you will conduct in Nigeria. And he did. Okay. I told you, the legislature and the current Attorney General's office, we've been working together, and that's why you see the smooth running of the judicial sector. So there was no plea bargaining since 2011, I think August, when it happened, until this January when the
Justice Talbot,
the
very controversial one.
The Talbot, and we don't know whether it was the prosecutor or the Honorable, I don't think it's the Honorable Attorney General's office. So the bill says categorically that, look, if you want to do, and why do we have to include plea bargaining? Because plea bargaining addresses the issue of delayed justice. In the US, 90% of cases
are solved by plea bargaining.
By plea bargaining, federal cases in the US. And why? Because there, the criminal trial is by jury. It's time consuming, it's expensive. So for them, plea bargaining is a case management system. It should be for Nigeria. Ours, we don't have a trial by jury, but our investigators are not thorough. They cannot gather evidence. Tell me which EFCC case has been concluded by a full trial. They are all by negotiation or plea bargaining or this. Because they were not thorough. So why can't we say, and if you are even looking at financial crimes, for God's sake, look at those 30,000 Nigerians that have been in prison for little offenses. Yes, perhaps they committed the offense and the police cannot let them go, but they don't have the evidence to secure conviction. So they will be kept there 5 years, 6 years, 7 years. That's what happens.
Sometimes even longer than the
even longer than that. So with this, the prosecutor will now call the accused, and he cannot do it without the investigating officer and say, look, we know you did this, you did this, you did this, but we cannot convict you. So if you plead guilty to this, instead of going for 5 years, we'll give you 2 years, 3 years. And if it is money if it involves money, you will refund the money. Once he agrees, you just go and meet the judge, and it has to be in the interest of public interest.
So the bill makes a specific provision for that?
Categorically, it specifies all these steps, and that it must be in the public interest. So the prosecutor and the police, you must make sure, it's unlike before, that you just go and do public plea bargaining. No, I have to be convinced, because you are doing that, you are prosecuting on behalf of Nigerians. I will now ask myself, is this plea bargaining in the interest of public? Because
who determines if it's in the interest of the public?
The prosecutor, the judge, and the accused. So the judge is there to look at it.
So the judge is involved in the process.
Involved.
Not what we have whereby the prosecutor and the defense agrees and then they take it to
and
the
then
judge.
the police is left out.
Okay.
Even the public now is included, because the public will now be able to determine, because before you don't even know what is going on. Now I'll be able to determine what crimes are you charged with, what lesser crime have you pleaded with, what are the sentences. Everybody will know. So it is now
under what law have
under
you
what
charged
law
now?
And then it is the duty on the prosecutor to do all that, and if he misses the step, he will be liable to some suit by Nigerians or by the authorities. Now in the public hearing, the bill, I mean, says the prosecutor can do that. So the NBA says, look, you have to anchor this, and people are saying, look, let there be no plea bargaining without the express authorization of the Attorney General. Some people say, no, not the Attorney General, let it be the DPP or the... So those are the little things that we're looking for.
And after the public hearing, what next?
Well, now we've collated the views of the Chief Justice of Nigeria, the heads of different courts in the country, the NBA, everybody. We have them. Now what we're doing for the next few weeks is to collate all those. We have consultants headed by Professor Kinshe George, a senior advocate of Nigeria, is a consultant of the committee on this bill. And we now sift and look at them and then remove those sections or those aspects of the law that are not, that people are. For us, we don't have any view. The view is what the experts and the Nigerians have said. So we'll gather those and then report back to the whole House. And the House will look at those sections, 400 of them, section by section, and then hopefully. We're driving it fast. The Speaker has given us a marching order that this bill must be passed within record time.
That's the program this week. Of course, Law Weekly will follow the progress of the bill and keep you updated as always. If you have questions or comments, please get in touch. The addresses are on the screen. I'm Shola Shayeli. Thank you for watching.